the motion, temporary reduction of maintenance or alimony?
Not today, Your Honor. I believe we were just going to be talking about the schedule today.
Okay. All right, we're gonna go on the record in Angel Antonio Rivera. He appears at his attorney's office, Ms. Story, by Zoom, separately from appearing. Well, she may not be appearing at all. Is she with you?
Yes, Your Honor. She is just lean over a little bit. Oh, the corner of my office. There she is.
Good morning. And then Maritza Lopez Morales appears with Caleb Smith, her newly retained attorney, who has entered his appearance recently. I don't have a copy of that, but sometime around the 13th of May. And we bumped this hearing from the 15th of May to today to give him a little more time to at least meet with his client and get a handle on the case. So what is currently pending is a motion for temporary reduction of spousal maintenance filed by the petitioner. And Ms. Story's also filed a proposed parenting summer schedule. Have you received that, Mr. Smith?
Briefly, I believe that was filed yesterday morning. Was that the one?
Yes.
Yes, just briefly. I was able to take a look at that.
Let me look. I'm trying to remember what their current schedule is. Ms. Story, will you remind me of, I'm looking for the Rule 170. There we go. Did we resolve the Rule 170 objections, Ms. Story?
No, Your Honor, the day that I filed them, I believe that's when we got a bounce back that Matthew was leaving Cordell. I believe, or it may have been the day that I found out that he was gone.
Well, tell me what our current visitation schedule is. I'm sorry.
So there's, today is her last day of school, so they're still on the school, the original temporary order. When we came to the hearing last time, they were ordered to go to mediation to figure out summer parenting plans. So right now, Dad has residential parenting time. And let me pull it up, Your Honor.
Well, I guess, Mr. Smith, what I'm getting at is I'm trying to figure out here if we go to shared residential for the summer, that should decrease the child support amount anyway for you, for him, Ms. Story, and we could leave the maintenance the same for now.
Yes, Your Honor.
So I'm not sure why that wouldn't be agreeable.
Your Honor, could you repeat that? We're having some auditory issues. I'm sorry.
If it continues, you might have to leave, go out and come back in. For some reason, that's been happening to us a lot lately. I don't know if it's on my, it must be on my end if you have to kick out and come back in because you can't hear me. So I'm trying to figure out with these recent motions, the motion to reduce spousal maintenance becomes less important if they move to a summer shared residential. Because there should be less child support.
I agree, Your Honor.
And I'm not sure why she wouldn't agree to a proposed shared summer plan. And then we keep the maintenance the same. And I don't think he's paying child support. Or is
He's paying child support. It's a small amount, and we need to rework it now that the child support guidelines have changed. And since getting her pay stub. So we're gonna update the child support worksheet. It should go up a little bit, I believe.
But I mean, does he still want a reduction in spousal maintenance if they're doing shared?
Yeah, he's okay with continuing paying what he's paying if they're still doing shared.
Until we can get this finalized, hopefully by fall?
Yes, yes. The issue was with Matthew's proposed child support worksheet that he filed with the Rule 170, it would have put my client in the negative. So that's why we filed the motion and the objection to the Rule 170.
Okay. And then I presume that the two of you haven't got really much of a chance to chat about trying to straighten out the journal entry and make any modifications that you might agree to.
We have tried to call each other. So when I tried to call him, he was in a hearing. And then when he tried to call me, I was in a hearing. So we've tried. And we have a plan to talk later today. So we've been trying.
Okay. Well, I'm kind of hoping that you can resolve this since we couldn't address it today. And I'm just trying to walk through with you thinking that maybe some of the issues could be sorted out if there's an agreement to shared residential for summer. But I suppose I haven't gone back and looked at the adopted temporary order. So how far would you like this set out, Mr. Smith? And the other thing is, I don't want to delay shared summer either if today's last day of school. I need my calendar. I'm not sure where I put it. On the bottom of everything.
And Your Honor, I think I was misunderstanding you before, but with the shared residential for the summer, my client does not want that to be happening since they weren't able to come to an agreement for mediation. My client's position is she wants the schedule to essentially stay what it has been, which is essentially opposing party to have a day during the week and for it not to be shared.
Your Honor, if I could comment on that. During
Yes.
the last hearing, it was required that he have a minimum of one night. When they went to mediation, he attempted to negotiate more, Your Honor. And as she has said, she wants him to have one night during the summer. The proposal that we have proposed is what he proposed in mediation in order to keep the relationship and the child schedule pretty even with the parents. She wants to see both of her parents. My client wants her to have time with both of the parents. So I don't think it's fair, Your Honor, for him to have one night during the summer when they have been going to the gym together and doing things together, which is why I requested we have just the summer parenting plan today. Because I do appreciate Caleb has not had a lot of time to be in the cases. It's not his fault. Things happen in firms. So I want him to be able to be prepared for all of the other things. But summer starts today and there is no set parenting plan. So there's nothing to say when my client would see her, when the child would be with either parent. That affects child support over the summer. That would affect spousal support over the summer. It'll just cause a lot of issues, and I don't want us to figure this out in August when we come back and my client potentially didn't have parenting time with her during the summer because mom wants her to have one night. So I am requesting that the court make a decision today about summer parenting time, because I just don't see the parties coming to an agreement. They couldn't come to an agreement in mediation. It sounds like today they're not going to come to an agreement.
Well, we can, Your Honor, we have a skeleton argument of why we can continue on with what we're going for, if that's agreeable, Your Honor, and we can have a ruling today if that works for everyone.
Well, first of all, Ms. Story, tell me what his hours are, and let me look at your proposed parenting plan again. I mean, she's, as I recall, a cook off during the summer, although she may need to get a summer job. What is he going to do with the child on the days that he has the child?
So we've tailored this. It's a little different. We have mom having her during the day from Monday 8 a.m. until Wednesday 5 p.m. each week. Then we have my client having her Thursday and her having Thursday and Friday 8 a.m. to 5 p.m. My client having her 5 p.m. and continuing till Thursday at 8 a.m. each week. And then, so essentially, when he's working, she is with her mom. And when my client is off, she is with her dad. We did that because eventually we also want mom to get a part-time job during the summer and leave some time for her to be able to work part-time. That's not going to be reasonable if she wants to be with the child all throughout the summer, and that's something that you've expressed to Mr. Mantilla in the last hearing and his client, that she may have to get a part-time job. So we try to make it to where both parties get some parenting time, an equal amount of parenting time. When my client is not working again, the child would be with him, and then the other times be with mom.
And then they rotate every other weekend.
Yeah, they alternate the weekends from Friday to Monday.
Okay. And Mr. Smith, your client's objection to this schedule?
Your Honor, my client has a few sort of quick objections. First of all, my client indicates that the opposing party has been to make his parenting time work, has been having to take the child to work with him all day. So the child has been getting up very early, being at work by 8 a.m., then just sort of sitting, during her days off, and would have to do that during the summer. And she indicates that, that would be very unfair to the child to be spending half of her summer sitting at a military base. That's not a very kid-friendly environment. Also, would not be the best interest for the child, while my client is currently does not have a part-time job. Maybe she will, maybe she won't, but even if she does, she'll have a very flexible employment, so she could be with the child. So the child wouldn't have to be just sort of sitting there at work, waiting for the day to be over. Also, I believe it has come up in previous hearings, I don't know, but my client also indicates that there's been some safety concerns at the opposing party's home, unsecured loaded firearms, and
We've
drawers.
already been through that. There's no evidence of that. And with his Air Force credentials, if he did such a thing, he would probably lose his job and all of his benefits.
Understood. Well,
I just
I will say
don't think that's legitimate.
Well, I will say I have been provided photographic evidence of that, Your Honor. So if we need to have a hearing of that later on, we would be able to provide
Your
pictures.
Honor, objection about that, because those exhibits were provided to the court and to me at the last hearing. And again, you made a ruling that all guns needed to be locked away, and we've already addressed that issue. I get Mr. Smith making an argument, but that's irrelevant at this point.
Yeah, what? So I don't know why I'm having difficulty with this, but apparently it appears that he wants to have the child every evening during the week and mom have the child all day, every day during the week. And then they alternate every other weekend. So the child would not be at the base at all. The child would be with dad at nighttime.
Your Honor, my client is saying that yes, the child would be at the base because opposing party, he's in the military. He doesn't have sort of standard hours like 9 to 5. It's not an office job. In fact, he's on call 24 hours a day, so he does often work at night. So the child would be at the base.
Well, I'm probably not gonna agree. I'm surprised they let them take a child to work.
Your
Um,
Honor, I can clarify the schedule a little bit for you. Monday, Tuesday, all day with mom. Wednesday through Friday, and overnights with mom, Monday to Tuesday. Wednesday through Friday during the day, 8 to 5 with mom. And then night with dad, and then alternating every other weekend. And to address being on base, she went on base one time, one weekend with him. It happened one time. He does not bring her to the base, and it was not something that was planned. And he doesn't anticipate that having to happen again.
Well, I think probably there needs to be a right of first refusal before he takes the child to work. Mom
Okay.
should get the child over the child going to work, unless the military has some kind of childcare there. And there may be times where he has situations where he has to arrange childcare there, but otherwise, I mean, I understand. I know people that have to take their kids to work for a while and give them an iPad and or an iPhone or do something and just kind of get by. But when mom's available, that doesn't make sense. So, well, Mr. Smith, I'm going to give dad more time during the summer. And if we can do, I don't always think shared's best during the school year. But I think if you can do a shared during the summer, where you don't have a lot of issues of the child getting to school and who's making sure the child's there on time and who's not, and who has to, take the child somewhere else early because of their work schedule. I mean, I just think, preferably, unless there are safety concerns, the child should spend as much time with both parents as they can possibly equally accomplish. And the firearm thing I've addressed. And if we need to send somebody over to inspect his house, we can do that. But I think he understands the gravity of that kind of thing. And I ordered that everything be locked up and secured. And that's just something every parent should know, and especially someone that's in the military. So unless there's some other kind of safety concern, I'm inclined to adopt this proposal. If there's problems, you can petition the court for a review. For the summer, I'm not guaranteeing that this is going to continue, but it's for the summer, and I'm going to require him to keep paying his maintenance payments. If you talk to your client and you get a chance to negotiate a little bit with Ms. Story and you say, Judge, this is just not acceptable, and my client's not getting due process, and I want a hearing, I'll find a hearing time for you before, as soon as I can. But I don't want to delay summer because we need another month for everybody to get ready to have a full-fledged hearing. And I think that I need to give some direction to your client in terms of, I think the state of affairs these days is basically if you have a workable shared situation and someone's not just doing it for financial interest, but is truly actively engaging as a parent, you try to make those equal plans work or close to equal. They don't have to be absolutely equal. And then if the person doesn't exercise their time or isn't responsible with the child, then that sort of privilege gets taken away. So I think that's what I'm going to do for today, because I feel like we shouldn't have a bunch of loose ends at this point. And I think I'm not interested in really reducing his maintenance at this point either. But I will take a look at that for them as well. But I think if we can get through the summer and you can either come to an agreement or we can figure out what our true triable issues are, we'll get the case tried, or you all will get it resolved. It doesn't sound like mediation is going to be, it's going to be between the attorneys and not really between the parties. And unfortunately, if a client doesn't get the benefit of their attorney talking to them generally about custody and domestic, I don't want to say policies, but the statutes and generally what courts tend to or inclined to do. Then when they go in to mediation, then they don't have any framework of reference, having had the benefit of sort of walking through all of it with their attorney. And I think that's unfortunate. And I don't believe she had the opportunity to spend time with you, Mr. Smith, before the mediation. Which is not your fault. But all right. Again, I will give you you work with your client, look at everything. Talk to Ms. Story. If you still want a hearing, I can get you a hearing in the next 30 days on the summer issue. But this is what I'm inclined to do, and I'm going to go ahead and order it because summer's here. And I'm going to deny their request right now for a temporary reduction of spousal support. And they can petition the court for a hearing as well. I'm not going to order them back into mediation. Oh, I know what I wanted to ask. So, Ms. Story, have you talked to your client about putting that San Antonio property on the market? Has anyone looked into that?
Yes, Your Honor. I actually tried to contact Mr. Smith yesterday and see if we could get an agreed order on file. I sent an agreed order a couple weeks ago. I do not believe that she is in agreement to sell the rental property at this point.
That's correct, Your Honor. Right now, my client does not want to put that on the market. That is her current position.
So we will be filing
the
a
problem
motion.
was, again, you didn't get the benefit of this, is he wanted less maintenance because he wanted some allocation for maintaining that property, because really the rent just barely covers the mortgage. And I had assumed probably that maybe there was some, since real estate values, I know interest rates have gone up and that's affected the market, but house prices have increased substantially as well. So if they had some equity in that home so they could both have some cash, I really thought that was probably their best avenue, since you know it's not that easy to maintain a property long distance. You've got to pay for everything for somebody to take care of it, and they don't have tons of, I don't think they put tons of money down on it. Do you know, Miss Story, is she entitled, if they get divorced, to use VA loans to purchase her own home or a new home? I mean, I don't know how many VA loans I guess they can get. If they buy a property where they're stationed and they keep it instead of selling it when they leave, and they buy another property where they're stationed, how many of those VA loans can they get? And can she get a VA loan given their current loan situation?
I can get as many VA loans as possible as long as there's a threshold, which I don't know the exact amount, but it's around like 650,000, I believe.
Okay.
But that's why I have two VA loans currently, the one from in San Antonio and the one here in Kansas.
Right.
But once I'm the only one that's able to apply for a VA loan, she will not be able to apply for one.
Yeah. Is your client wanting to potentially go back to San Antonio? Is that why?
Your Honor, my client at some point would like to sell the rental property, but short term there's some issues. The opposing counsel has closed her credit card. She has some short-term issues with credit, and there's some parts of the agreement that she just of the proposal that she doesn't particularly agree with. So she wants to revisit the proposal that they've submitted.
Okay, well, you're gonna have to request a hearing on that then if you can't come to an agreement. And I'm not gonna push that to the detriment of either one of the parties. There could be a lot of moving parts that I'm not aware of with it. It's just initially my thought was he can't afford two residences, and it's not fair to her that she doesn't get the support she needs currently because they're having to subsidize that house in San Antonio. That may bring him a little bit of liquidity, but I may not be correct, and those may be a lot of assumptions. So I'll leave it up to you. And then I'll wait to hear if you need a hearing. I do want to give you a review date. Do I need to give you some discovery deadlines, or is that too premature for you as well, Mr. Smith? To know that.
That might be a little bit premature. I know that we have some
Okay.
discovery out.
Okay.
I'll send that back to you, Caleb. I believe we sent you everything. We sent everything back to Matthew, but I will resend that to you to make sure that you have it.
I appreciate that. Thank you.
You're welcome.
Oh, that's because of my vacation. Because I'm not seeing an August domestic day, but that's because I'm gone the 1st through the 15th, which is the longest I've ever been gone.
We have one July 31st, and then I have one scheduled August 14th.
Okay, maybe I missed that.
And then we don't have another one until September 16th.
There, I must have missed. How about we review this on August 14th? Or you can have the September date, or I wonder if we need to do an August 25th domestic day before I leave, Amy. Well, we'll see. The 14th is not booked at all at this point, but it will before school. I'll get booked up. So you can have September the 16th or August the 14th for review. Whichever you guys prefer.
Your Honor, I do have a question. We're attempting to get the house on the market before August because he's not going to have the new tenants in the home, so he'll be paying
Right, if you don't come to an agreement, I'll give you a hearing before then. I just want to
Oh.
keep this on the books. I never take these cases off calendar. Once we get on calendar, I never take them off the calendar because I don't want to lose track
Okay,
of them. So I always set review dates. They're just status conferences.
okay. I just wanted to make sure, Your Honor. Thank you.
Yes, no, maybe make a note that we're not gonna push them off to that date if they have issues that we need to address. So given that, would you rather have this September date? If you know that I'll give you a hearing date before then, if you need it for anything?
Yeah, I'm good with whatever works for Mr. Smith's schedule.
Okay,
Either works for me, Your Honor.
would it be your preference to touch base in August or September? Before school starts or after?
August 14th works. We can do it before or right around the time that school starts.
Okay. All right, so August 14th, I have the whole day open. What time would you like?
My client prefers mornings if that works.
Okay, just 9 AM again?
That works.
That
Okay,
works, Your Honor.
all right, we will definitely see you that day. And I'll see you before then if you two can't come to an agreement on some of these other things, or you decide that you want a hearing for a morning or afternoon. I probably can't give you an all day or a 2-day or anything like that, but I can give you 2.5 hours. I can find that for you. Okay?